Jazakallah khair, Brother Humayun. Thank you all for taking this time this evening to attend. So we're going to be diving into some important topics here around estate planning. And so there's going to be a lot of information, and we'll definitely leave some time at the end for questions. So really, what is the purpose of estate planning? It's a term that often many of us hear about, but really what it's about preserving the assets that you've spent a lifetime building. It's about protecting your spouse, your children, or other heirs that you might have, and ensuring that your assets are then distributed how and when you want them to be in accordance to the Islamic guidelines. And estate management is also about managing the amount of estate taxes, if that might be an issue that could be due after your death. So there are some fundamental estate management principles, of course, that can help you manage your financial and personal affairs both during your lifetime and then also helping you distribute your wealth after your death. So please keep in mind that the information that we're going to talk about today is not intended as tax advice or legal advice. It is not for the purpose of, again, avoiding any sort of federal tax issues. So just disclaimer, consult a professional for specific information regarding your personal individual situation. So with that, let's talk about what is an estate plan. And simply put, it's a map of how you want your personal and financial affairs to be handled, either in the case of incapacity during your lifetime or death. And again, the subsequent implementation of those strategies that are going to help fulfill those objectives for you. So, what is the top reason sometimes people ask about, okay, why do I need to have an estate plan? And I think most people, they say they want to provide for their family financially, but there could also be things like supporting their loved ones in other ways. They may want to make the process of inheritance after they're gone easy. They may want to name someone to look after their minor children. For example, naming a guardian for your children in your will so that you can make sure that they're being cared and raised by someone that you trust. And for some people, it might be keeping details of their money and property private after they're gone. And for that, there are tools such as trust, which we'll talk about a little bit later. So there's many components, of course, to estate planning, and I've listed a few of them on your screen. And again, this is a topic that can sometimes get overwhelming when we look at the particulars. But we will get into some of these scenarios, but I think it's important to really think about the big picture. So when your estate planning is done right, the point is it should provide peace of mind for you and your family. And estate plan can also enable you to spell out your healthcare wishes in ways that can help ensure that they're carried out, especially in circumstances maybe where you're not able to communicate anymore. And it can also ensure that possessions go to rightful heirs, hopefully avoiding, any sort of legal wrangling that can tie up your estate or even cause disputes or deviations within the family. And through effective estate management, you can also avoid some expenses and legal costs. And like I said, you can provide for loved ones who may not be otherwise protected. So all of these issues become important when determining how to design your estate plan and thinking about these things in advance. So let's talk a little bit about the must-haves now, because like I said, it can be an overwhelming topic. So let's talk about a few of the things that everyone here today should have. The first is a will. And a will is something that can appoint guardians for your children, and it can also spell out specifically how you want your property to be split. Without a will, any individual who leaves assets without a beneficiary may encounter those assets passing according to your state's laws, not how you want it to be distributed. And if you want to make sure that your estate is distributed according to Islamic inheritance guidelines, at the very least, you need to have a will. Now, there's also something called a living trust, and a living trust can be also an important tool to avoid probate, which we'll talk a little bit more about, that can add in privacy and make it easier for your family to, again, have control over the distribution of your assets after you're gone. Now, the next two, I would say people sometimes overlook. They say, oh, I need a will. but they don't think about instances where they may be incapacitated during their lifetime. So a healthcare power of attorney is also important because it can allow you to designate a healthcare agent to make healthcare decisions in the event you're unable to make those for yourself. Now, in addition to healthcare, what if you are incapacitated? What happens if you have a bill that needs to be paid or you need to have a check cashed? In that case, you also want to have a financial or property power of attorney. And that's someone that you can designate as an agent to make financial decisions in the event you're unable to make decisions yourself. And even in instances where, for example, you may have a IRA account or an annuity or some other product that has a beneficiary designation, I'd say it's also very important to periodically review those beneficiary designations and make sure that it's coordinated to your overall goals and your overall financial plan. And same thing can happen to joint accounts. So, if you have a joint account with someone, what that means is not that it's always 50-50. If it's joint with right of survivorship, as most joint accounts are often opened, it can mean that both parties own the account 100%. So if one passes away, the 100% goes to that joint surviving owner then. And so it's important to also review co-ownership provisions and the titling of those accounts. Now, there are additional kinds of trusts I'm not going to go into detail with, but for example, if you have someone with special needs in your family, there may be additional planning considerations so that, again, they can be protected and cared for while also maintaining certain governmental benefits. If you have an estate or you have maybe an occupation where there's concern of asset protection, there are other types of trusts that can offer asset protection. So there are a lot more complex types of planning that can include like LLCs, family LLPs, and asset protection trusts. But we're not going to go into that complexity or detail today. So what happens if you die without an estate plan? Essentially, what happens is that you haven't named or created a will to say what happens to those assets. So if it's not something that has a beneficiary designation or owned jointly, in that case, a court is going to determine who gets your belongings during a process called probate. And without a will, the court is going to rely on your state's laws of intestacy, which again may or may not include the people who are important to receive inheritance, who have a right to receive inheritance from an Islamic perspective. And also, it may not necessarily all be people who, again, would have that right. There are certain relationships where maybe it's grandchildren or children may or may not receive an inheritance through the intestacy laws. So again, very few people, I would say, really understand what happens to their estates after they die. But in cases where there is no estate plan, unfortunately, neither you nor your family have really any control at that point how that money might be distributed. So, for example, let's say you have $5,000 in an account in your own name. You never had a beneficiary assigned to it. In that case, who would the money go to? Without instructions from you, the money is going to go to, again, the people or persons that your state's intestacy laws say it should go to. And these are laws which can vary from state to state, but this is actually a typical, I would say, distribution, maybe where 50% of the property goes to the spouse, 50% is divided among the children. But again, every state is going to be different. And regardless of what that percentage is, I think the biggest issue is that these are not your actual wishes. This is not what you would have wanted or what you would have said. So again, without an estate plan, your actual wishes, don't matter. And again, if you want it to be distributed according to Islamic inheritance, then definitely it's not going to be doing that. Now, there is a simple way to avoid intestacy, and that's simply through creating a will. And a will, sometimes it's called a living will and testament. It has a few different names, but a will is probably one of the most vital pieces of anyone's estate plan. And it's a legal document that directs how your property will be dispersed when you die. And it also allows you to name someone called an executor. An executor is someone who you name who's going to carry out your wishes. And this document can also help you establish a guardian if you have minor children and you want to say, look, I want these people or this person to be the one who takes care of my children, or maybe I want this other family member to be responsible financially so for the children. So you can actually spell all of that out in a will. And you can also sometimes use your will for other things like tax planning. But again, a will really has to be valid. And in order to do that, it has to be in writing and it has to be signed by you. Every state's requirements vary. So some states may require a certain number of witnesses, some may require notaries. And these are going to be really important to follow because if you aren't careful, it is possible that your will might be invalid. Now, again, the big consideration for having a will is, again, the fact that it's going to go through that process called probate. So even if you have created a will, usually things can go smoothly in the probate process. It can last anywhere from a few months to a year. But if you do have an estate that's larger, it could take longer. And that can mean that your estate may be tied up. And if you have family members who are in need of that money, again, they may not have access to the assets in your estate. So there are ways, again, to help in avoiding this probate process. For small estates, probate may not be a big issue. This can also vary state by state. But again, in some instances, it can take, even up to 2 years or more. And again, it basically means that your family has less control over the process. If you also have assets in more than one state, for example, maybe you own a home in Maryland and a condo in Pennsylvania, your executor is now going to have to file in each state where the property is located. So this can, again, create additional complexities for your family. And again, all of these issues are probably not what you want to leave your family with to deal with, especially whenever they may be going through a difficult time as it is. Now, one way that you can design an estate plan to avoid that whole probate process is to use a trust. And a trust is a common and I would say very versatile estate planning tool. We've already seen again that having this kind of trust can help us in avoiding probate. So in addition, you could use this trust, to professionally manage your assets. You can include in that trust certain safeguards for minor children or elderly parents and other beneficiaries. You can also sometimes create certain trusts to protect those family members from future creditors. So, for example, if you're leaving money for children or for a special needs child, you want to have protections in place that money will be protected for their use and for their benefit. But overall, it's going to allow you to maintain a degree of control after the property is placed in the trust, and this is even after your death. So one common question I often get is, okay, there's a will, there's a trust. How are these really different from each other? Do I need one? Do I need both? And a major difference between a will and a trust is that a will goes into effect after you die. So it's a document that is there, it's instructions, but it goes into effect after you pass away. Versus a trust is something that goes into effect the moment you create it. So once you create it and you sign it, it becomes a living, breathing document. And it's really a tool that can be used for you to, again, manage your affairs, again, sometimes during your lifetime, but also allows you to appoint a trustee who will be able to continue to manage those affairs after your death. And that trustee, again, can be given instruction, for example, to distribute your assets according to the Islamic inheritance distribution. Now, this is actually, I would say, a very interesting point. The Prophet Muhammad, peace and blessings be upon him, used to encourage his companions to actually learn the knowledge of the inheritance. And he said that it was half of the knowledge of fiqh. And furthermore, the Prophet warned that his followers that the knowledge of inheritance is subject to be forgotten. And at the end of time, it will fade away and vanish. And, I think this is This is obviously a very technical type of knowledge. I can personally say that before I entered the field, I had very limited understanding of what Islamic inheritance was. So I would encourage, everyone to take some time to try to understand some basics, at least, of Islamic inheritance and what that means. And we're going to go over a little bit of that today. So, as you can imagine, when we're talking about, trusts and wills, it creates obviously some complexities for us as Muslims living here in America. If we want to take trusts off of a typical online tool, it's going to have language in there that is contrary to Islamic guidance. Even if we go maybe to an attorney who has our best interest, they may not understand again what kind of Islamic inheritance requirements are there, or even in terms of how to handle other aspects. For example, oftentimes I'll review a will or a trust, and it was designed and it talks about things like cremation, right? And they may not be aware that this is not something that we would want included in as a part of our legal documents, or there may be a provision in there talking about if someone predeceases someone else within a certain number of days, act as if they died at a time different than their actual death, which again, we can't do as a part of Islamic law. So there are these aspects within these documents, which again, may not fit within our values. And of course, we have inheritance planning, which we'll get into a little bit. We don't have, Sharia courts here. So again, like I was saying before, we have intestacy laws. Every state is different. That is how our assets will be distributed if we don't have anything written. And again, there is also the opportunity to talk about preserving wealth, utilizing tools again to ensure that our family is taken care of, as well as charities. And that's again, I think, where we start talking about the legacy. What is it really, the legacy that we want to leave? How do we want to create wealth, inshallah, in our lives that again our family can use in a beneficial way, and also how can that wealth be used again to support the community? So, again, if any of you have not heard a lot about Islamic inheritance or done a lot of research, obviously there's some things that some of us may have heard. And there are myths, right? For example, that sometimes make this a very challenging topic for us to approach. Sometimes, the only thing people know about Islamic inheritance is that, oh, males get more than females, or that, there's no way for me to be able to do this. This is way too complicated. This is a whole technical area of fiqh. And it's going to be very expensive and complicated. This is too much for me. Or this idea that, oh, what I've earned in this lifetime, it's a privilege. I can decide who I want to give it to. If I want to leave it all to my cat, I can do that. It's my choice. So there's all of these kind of ideas, and I would say emotions behind estate planning. And probably one of the reasons why most of us put this topic as much on the back burner of our planning as possible. Most of us are not excited to, get their will done, think about how all of this is going to be figured out. And so again, oftentimes we just keep, postponing it. So I wanted to kind of talk a little bit about some of the characteristics, of Islamic inheritance, so that we can get kind of a basic understanding of how it works and how it's different maybe from conventional planning that people might be doing if they're not Muslim. So from an Islamic inheritance perspective, we have the idea of heirs. And when we talk about heirs, it's not who do I want to give to, right? Okay, I have children, I have people that I care about, I want to take care of, I'd like to give them money. But we have to first come from it from a perspective that the heirs, from an Islamic perspective, have rights. This is not a privilege. So our responsibility in creating our estate plan is not to give whoever we want to give money to. It is to maintain the rights of those people to inherit. So that's our number one priority, our number one responsibility as Muslims whenever we are creating our estate plan. Secondly, a unique characteristic, I would say, of Islamic inheritance planning is that, again, it recognizes individual ownership. There is no real such thing as joint ownership. Every asset is owned by an individual. as I mentioned earlier, typical joint ownership, if you have a joint bank account, for example, with a spouse, it's not that each of us owns 50%. It's that both of us own 100%. And because my heirs may be different than, for example, my husband's heirs, under Islamic inheritance, there is no really such thing as joint ownership. My heirs, for example, would maybe we have common heirs, which would be our children, but I may have separate heirs from my husband. If my parents are living, my parents are my heirs as well, and they have a right to inheritance, as do his parents have a right to his inheritance. So that's an important distinction as well. Also, the fact that only surviving heirs inherit, and this might just be something that seems to be common knowledge or makes sense, but if you actually read a lot of trusts and wills, it actually doesn't always follow this principle. So from an Islamic perspective, if someone predeceases, then their share is not there. Only those who survive at the time of death, again, maintain their right to inherit. Now, in terms of Islamic inheritance, again, it's a mandatory intestacy inheritance system. So, like we were saying before, intestacy laws in each state might be, this is the distribution. Same thing under Islamic law, there is a mandated distribution that is there. And again, this means that the estate of a decedent is distributed according to a prescribed share, which is a formula. And again, this goes back to Surah Nisa. And we'll talk a little bit more about that as well. Now, although there are certain heirs who have a right to inherit, there is some flexibility. So sometimes people again have this notion that, oh, Islamic inheritance is so rigid. There's no way that it's going to allow me any room to fulfill maybe the needs that I see, the concerns that I have. And so now I just have to choose. Either I'm going to do it Islamically or I'm not. And that's also not the case. So Islamic wealth transfer also does have some flexibility. So in one is that it allows for gifting and donating and making awqaf. This can all be done during lifetime. It shouldn't be done again once someone has a terminal illness. But again, while you're healthy and you're alive, you can gift. For example, if I see that maybe one of my children might have a certain need more than the other, I could gift in that case to be fair, but I shouldn't again create disagreements among the family. So again, I can make gifts again to address those concerns. Or for example, I have a spouse who may not have, maybe the inheritance that the spouse would receive wouldn't be sufficient enough for them to financially care for their family. I can gift to them. So there is lifetime gifting that can be done, and there's no percentage requirement or maximum minimum in terms of gifting. And then finally, there is the wasiyyah also, right? So the wasiyyah is 1/3. And it can be 1/3 of your total estate value, which can be given to anyone. This is 1/3 which you have complete discretion and flexibility on. And it can be given to anyone, for example, who is not a natural heir. Now, those people, for example, who have a right to inherit are not usually eligible for that 1/3 unless all the heirs approve. So for example, if I have two children, they both have a right to inherit from me. I can't say, well, one of my children is going to get their share plus 1/3, right? Unless all of the heirs approve of that. But if I have charitable intentions and I say, alhamdulillah, I've left for my family to, what they need to be financially sufficient, and I really care about charity, I really want to leave helping hand with relief and development, some money to go towards their endowment or towards a project or anything else, I have flexibility to use that 1/3. And that 1/3 can also go to other individuals. For example, I may have a non-relative or a distant relative, right, who I may be providing financial support for. I can include them as a part of that 1/3. I may have a non-Muslim relative who is not an heir. They can receive up to 1/3. And this can address a lot of family concerns as well. For example, converts who may again want to leave something to their non-Muslim family members, there is flexibility for them to be able to do that. And subhanAllah, sometimes that can even allow them to leave more than maybe what a natural heir might have the right to inherit. So I just wanted to put that in because again, it isn't this, cut and dry, no other options. And that's actually one thing that I work with my clients on is again, trying to understand what their needs are and then utilizing these various different tools that we have within the Sharia to make sure that again we're following Islamic guidelines, but we're also addressing again the planning and needs for the family. So in terms of the heirs, I would say there's three. We can kind of divide it into three main types of heirs. One are the Quranic mandated heirs, so they have a mandate to receive a share. Then there are the residuary shares. So I think this could be probably best explained maybe with an example. Let's say, for example, someone passes away and they have a mother and a son, right, who are surviving and that are their heirs. In this case, the mother has a mandated percentage. So she will get her mandated percentage and the son will be a residuary heir. He will receive the remainder of the estate. In very rare instances, for example, where there may not be these like close family ties, there could be other relatives, which we will call distant kindred, who may also be eligible for inheritance. And we can divide the inheritors into two categories. Typically, there's the Sahabul Furud, again, and they can be again, both men and women. And then there is the ones who are typically mainly the male relatives of the deceased. And again, I would say like one of the myth busters that we were talking about earlier, like only men get more than women. If we look actually at the women who have a right to inherit, again, the mandate for women to inherit again goes back to the idea of protecting the women within the family as well. So again, these you can look more into this research more, but I wanted to at least give some basic background and understanding of how the Islamic inheritance works. So, as Muslims, are we obligated to have a Sharia compliant estate plan? We talked about intestacy laws, and you can see that if you don't do something, if you don't have an estate plan, then it's going to go according to your state's law. So for this reason, many shuyukh have stated that for Muslims living in America, they're obligated to have an Islamic estate plan. So this is really something we all should make a priority to make sure that we have, and not put it on that back burner anymore. Now, this is a distribution when someone reads a simple will. So going back to the documents now, how do we implement these rules of inheritance with the documents that we've talked about before, the strategies, for example, having a will, having a trust, right? So one way is you can say, look, I'm just going to create a simple will. My main goal is for the inheritance distribution to be completed. And I need to provide instruction to the courts, to the probate courts, what that distribution should be. So you can do that through a simple will, where you have a will and you name, again, those heirs and, again, the percentages. There are now different, I would say, tools where it will help you calculate the percentage. I think we have Brother Abed Awad joining on another webinar, and I would encourage everyone to attend that. He is an estate planning attorney specializing in Islamic law, and I think he'll probably be going into more detail about this. But again, this can either be an attachment of the Islamic inheritance rules to the will, or again, there can be a way to define, who those people are. But this is I would say, a very simplistic way that this can be accomplished. Now, of course, even if you create a will, one thing to keep in mind is that if you are owning your assets jointly, then when one spouse passes away, or the first joint owner passes away, 100% of that asset is going to go to the second spouse, the surviving spouse. And in this case, there is no document that states, well, maybe there were other heirs that should have received an inheritance. And then when that second spouse passes away, it's now going to go to the heirs of the surviving spouse. So let's go back to that example where I was talking about, for example, me and my spouse, right? So if we have a joint account, I pass away, everything is going to go to him. Now, when he passes away, everything is going to go to his heirs. But what if I had living parents and they had a right to my assets? They will now be disinherited, right? And so that creates a challenge whenever you're owning everything jointly and you haven't taken this into consideration. So again, within Islamic inheritance distribution, we have the heirs, up to 2/3, again, are those that have a right to inherit, and 1/3 who you can name as a wasiyyah, it can be other beneficiaries. So can be done, again, through a distribution in either a simple will or in through a trust. And these are all tools that you can, again, put together and work together. So there is the wasiyyah, there is the inheritance, there is gifting, and there is a specialized trust, right? Where you can, again, also make sure that the rules of the distribution are there, but also it's now avoiding probate. So sometimes people say, okay, well, I have a trust, but what is an Islamic trust? And essentially, this is a trust that is including the Islamic guidelines. So it can be a document that is revocable, so you can update it during your lifetime. And again, it's a document that can allow you to transfer the ownership of your assets after death. And in this case, you would appoint a trustee. Again, it could be anyone that you trust, to put it simply. And they can be in charge then of making sure that the trust is actually following the instructions of the trust. Now, there is one additional structure, and again, I think probably Brother Abid Awad will talk about this, during the next session. But there is also the Waqf Al-Ahli, and what a Waqf Al-Ahli is, this is a family waqf, and this is a type of specialized trust that Muslims have actually utilized for family planning and estate planning for thousands of years. And so as a company, when we began doing estate planning for our clients back in 2009, 2010, of course, we encountered many challenges because, again, our families here, living in the U.S. are often structured so that, again, not everyone would be fully provided for just with the inheritance distribution. So we had to look for ways that, again, within the Islamic guidelines, how could we address concerns of, for example, taking care of a special needs child, taking care of a spouse who may have less assets, dealing with, in some cases, large and complex estates where, again, there could potentially be taxation and loss of wealth for the family if things aren't structured a certain way. So the Waqf Al-Ahli was a model that we researched and we were able to utilize, again, to allow some of that flexibility. And again, it can offer many of the different benefits of a regular trust that non-Muslims enjoy, here in the US. But again, we can customize it to ensure, again, it's following the Islamic guidelines. So with this, simply, a trust is basically an agreement. And when you use Waqf Al-Ahli, that trust becomes the Waqf agreement. And same thing, you have a trustee who is going to manage the trust property. According to the trust agreement, you have beneficiaries who can benefit. And then finally, you can have Islamic heirs who finally receive the distribution when the Waqf terminates. So a few key takeaways. I think, first of all, sometimes we, again, have things scattered around. And so it's a great idea to take inventory of your assets and just see how they're currently titled. What would happen if you were to pass away today? What are your beneficiary designations? Maybe you have a 401k that you started with your employer 15 years ago. And at that time, you had named some beneficiaries. Since then, your family has grown and changed. Have you updated those beneficiary designations? Does your family know about your wishes, even basic wishes about, where do you have, where you would want to, for example, be buried? Do you have certain cemeteries in your area? Even though sometimes these very basic things, when we talk to families, these can be very overwhelming during a difficult time. So talking to your family about these things can make things very easy. If you say, look, just, I would like to be buried as quickly as possible in, the closest cemetery, even that, can sometimes make things much easier for your family later on. So have those open conversations. And if you already have some of these documents we've talked about, review them, because again, documents can get outdated. So see, like, the person you named as your executor, your power of attorney, are those still good people that you want to keep named? Or maybe have other people come into your life, have your children grown up and now be able to take those roles. You can determine again if there's any special considerations for your family, and of course address that. And finally, putting a plan in a safe place. I would say that, another thing to keep in mind is that as we've come into this new digital era, we also have to keep account of the fact that we may have digital assets, we may have passwords, we may have logins, right? So all of these things also, you may want to think about and say, look, if I were to be gone today, how can I make things the easiest for my family? And if you can put all that together in one convenient place, let your family know, that might be, one of the best things that you can help them in preparing for when you're gone. So with that, I will pause, and inshallah, we can open it up for questions.
Jazakallah khair, Sister Fatma. I have two questions. You talked about heirs. Yes, we all know that parents are by natural heirs, but I have read that brothers and sisters, if they are alive, they also are part of heirs. Is that true?
Yeah, it depends again on who is living. So there are certain heirs, for example, which can block other heirs. So in that case, for example, if you have a living son, in that case, he may block his aunts and uncles from being heirs. So so again, the heirs can change based on who is living and who is passed. So it's not that I have the same set of heirs, my whole life. My heirs may change depending on, again, who passes away and who's born, because only those who are living have a right to inherit. And I'll give a plug to Brother Abid Awad's Sharia Wiz as well. He's going to be on. He actually has a calculator on his website where you can go shariawiz.com, and there's an inheritance calculator where you can actually enter based on different schools of thought. You can select which one applies, best to you, and it'll ask you a series of questions, who, in terms of who is living, and then it will tell you who your actual heirs are. And I do see in the chat, thank you for this clarification. Someone mentioned that, the 1/3 Wasiyyah and the inheritance, even, I should clarify, is actually after all the debts are paid. So first thing is that you have to have all your debts paid, including, for example, final expenses, and then the inheritance actually applies.
Another question came up, Sister Fatma, here, and then I'll open the floor if anybody wants to ask themselves.
Sure.
I created my will when I was in Michigan. Now I am living in New Hampshire. Do I have to change it, redo it, or just add an addendum to it?
Yes. So I will say this, every state can have different laws. So it is a good idea to review your plan if you've moved, because states can handle things differently. One thing, for example, states can have different estate tax laws. So what estate taxes are, this is an additional tax which your estate pays after you die when your estate is over a certain threshold. From a federal perspective, from a federal estate tax planning perspective, the number is very high. It's around 13 million. So it's not going to affect a lot of families not a lot of families probably have more than 13 million. But some states have a lower threshold. So for example, Illinois has a lower state estate tax threshold. And so those are things that you should be aware of. So it's definitely a good idea to review your plan if you've had major changes like a move, deaths and births within the family, marriage, divorce, any of these key, I would say life events.
I'll open up the floor if anybody else wants to ask a question. I'm trying to keep up with that, but I've missed a few online. So please, you guys you can unmute yourself and ask a question. We have about 8 minutes for
So
questions.
if there aren't any, I can go through some of the chat questions again. Do heirs have to be Muslims? Yes, they do have to be Muslim. And again, there's a lot of situations that we encounter, and again, Muslim families are dynamic. Like I work, for example, with some families where, the children have left the faith, that they have left Islam, and how do families handle those situations, right? So, while those children would have been an heir because they are no longer Muslim, they are no longer a rightful heir, but the parents can still give to them through the wasiyyah, through the 1/3. But again, they are not included within that 2/3 distribution. So again, and same thing as I mentioned before, maybe there's instances where someone has come into Islam, but they have, family members who have not, but they still love them, they still want to leave them something. There is flexibility for them to give to them through the wasiyyah as well.
Anybody wants to ask a question, please?
I see
Yes,
another question. Oh, sorry.
Okay.
Yes,
Go ahead,
my
brother.
name is Mohammed. I'm from Boston, Massachusetts. Thanks for a wonderful presentation. I think everybody need to listen to this presentation. My question is about if you want to start the real estate planning in view of the tax exposures of the state, how long it going to take to complete this, and just estimated cost associated with this?
Yeah, so there's a range of how you can do your estate plan. I mean, you can, you can use templates, including online templates. You can work with an attorney. And believe it or not, some states also recognize a handwritten will, something that you would write out by hand, right? So the cost can obviously vary from free to, I would say, like working with an attorney and the documents that we talked about that are necessary, which is a will, a trust, power of attorney, healthcare directive. Right now, I would say like typically for a couple will range anywhere from like 3,000 to 6,000, 7,000, right? And that's maybe I would say a general range. So there can be a varying cost. And obviously like the complexity of your estate plan may dictate again that cost. If you do have assets in multiple states, if you do have circumstances within your family of someone needing special care or asset protection, you definitely are going to be wanting to work with an attorney. Or if you have, again, a large estate, right, where there may be tax implications, you'll want to be working with a lawyer. There are tools now available where you can create an online trust or an online will. There are, of course, a lot of them that are available from the conventional perspective. And a lot of these tools have made it very easy where they ask you question by question and you answer them and it creates a document for you and tells you how you should sign it and notarize it. And it's kind of a do-yourself at a pretty low cost. But those you have to be careful with because again, if they're not coming from, or designed with the Islamic knowledge, then again, they're not going to follow, Islamic inheritance and Islamic guidelines. But there are now also those that have been designed that do follow the Islamic guidelines, and most of those again have been reviewed by attorneys in each state, and they're valid in each state. And I would say like the cost of those can actually be like a few $100s, so significantly less. But definitely, I would say, whenever you have something more complicated, seeking out legal advice is always good.
If somebody want to start the process, who should they contact? Just your 800 number I saw on the website? Or there's any other specific number, a person to contact?
Yeah, so actually we don't actually do estate planning in terms of like the document creation because we're financial planners. So we help our clients again understand what their needs are, design a plan, and again understand okay what direction do they need to go, and then work with estate planning attorneys. So what I would advise is that you can reach out again to estate planning attorneys. There are several. I think Brother Humayun can definitely refer you to some Muslim estate planning attorneys who are, again, have been providing support to the donor base of Helping Hand for Relief and Development. And then there's also some online tools, like I mentioned, Sharia-Wiz is one of them. And I believe there's a few others out there as well. And I think there's also going to be some more sessions with attorneys who are actually planning to do that, planning to talk more about this topic as well.
Thank you.
Before we go, just a little bit of, I know a lot of questions will be answered with these few statements I'm going to make. There are two more sessions planned, November 19th with Brother Abid. December 4th, we are working on it. That will be in the morning with Brother Furqan from Chicago. Brother Abid is based in New York, New Jersey. Brother Furqan is in Chicago. They are both vetted by us very rigorously and recommended by Sister Fatma and her organization as Sharia-compliant attorneys. Both of them have been doing this work for years. And I will share an email to all of you with Sister Fatma's contact, Brother Abid's contact, Brother Furqan's contact, and Brother Yasir Ali from California. He's another lawyer we work with. All these three lawyers can make your wills, estate plans, or trusts. We do have shariaviz.com where you can make your own will and estate plans as long as it's simplified and you understand what you're doing. They have made it state specific. The same way Brother Furqan is islamicwillsusa.com. That's also do it yourself. You can do that. So these are all tools available. And then Sharia Viz has offered first 50 clients who sign up on their website or reach out to them, they will be 50% off on their will creation, which is funded by HHRD as our partner. So we can do it, but you can reach out to me anytime and I can provide that information. And I'll try to get that email out to you by this weekend, inshallah. And the recording will be available. All this information we are providing is available on our website, hhrd.org/plangiving, hhrd.org/endowment fund, and things like that. So,
Brother Maya, I'd like to just add one more thing.
Sure.
Sister Zubaydah made a comment here, which I think is really insightful. I think, this is knowledge, again, that we all need to try to understand and learn. It's not enough to rely on, oh, so-and-so said they're Muslim, they know how to do it, because this is a very specialized knowledge. So, even there may be people in the community who may be Muslim or Muslim attorneys, again, they may not have the full understanding and knowledge. So again, I think it ultimately boils down to all of us. We all need to, understand this more, so that again, we can make sure that not only we can create our estate plans, but inshallah, when our children see our estate plans, when we're gone, and they will open up our will or our trust and they will read it and they will understand that, okay, my parents, they invested so much time for me to be Muslim, and they actually did their estate plan, in that way as well. Hopefully, inshallah, that will be incentive for them to carry that on for their children. But, again, I definitely see circumstances where people, it's the last thing people are thinking about. And so again, I definitely agree with the Sister Zubaydah's comment. Thank you for that.